Well, good morning, everybody. My name is John Giardinelli. I'm your association's attorney, and this is John's Rants for this month. And what we're going to do today is talk about a sort of a potpourri. One topic that I wanted to clear up. I, I hear the term a lot, probably more than I should, and it's that, well, it only takes one to list, but two to sell. And I hear that, and what that really means is that the listing agent doesn't necessarily have all of the signatures that it would take to accept an offer should one come in through the listing or by other marketing means. And I want to kind of go over that because, as with most things from a legal standpoint, it's not as simple as all that. So, a couple of things real quick. One to sell or one to list, two to sell. What does that really mean? Well, there's contract law, and contract law is not real clear, but in talking to the attorney for the multiple listing service and talking to the attorney for the Department of Real Estate, there really is no strict law against taking a listing from less than all of the people that own the property. So that's number one. It's not technically against the law. But the problem is that once you take a listing and you market the property and do all the work that you folks do to make sure that the property gets sold for its best price under the best terms, how do you then accept an offer? Now you've got to scurry around, and under whatever facts or circumstances exist, you've got to get all the other signatures because title's going to want it, escrow's going to want it, and if there's a lender involved, they're going to want it. And so again, the question really becomes: is the listing now enforceable? And what is it that you're going to need to do to bring this thing home? Couple of things from a legal perspective. Number one, there's whenever you're acting as an agent, whether it's in real estate or any other matter, there are several kinds of authorities that agents have. Obviously, there's express authority. Express authority is the authority that you're given by a writing of some sort. In your case, a listing, or if it's on the buyer side, a buyer-broker representation agreement. And that express agreement can be, as I said, a listing agreement. It could be a resolution that is passed by either a board of directors, a partnership, or the managing members of an LLC. It could be through a court order. For example, if there's a divorce or a probate or a conservatorship, a court could issue an order granting you written authority to act on behalf of this particular property. Then there's a parent authority. That's the authority that I think you have because of the circumstances of the situation, right? You're actively listing a property, you're actively marketing the property, you're actively analyzing and conveying offers to your client. So in my mind, you're acting with the authority that you need to bring this property into escrow. But the reality may be that you don't have that authority, and that's where we need to take a look at a couple of other issues. Because if you don't have the authority, either by let's say, for example, the property is being sold by a family trust. Well, what does the certificate of trust require? Does it allow one trustee? Do you have written authority from a co-trustee? If it's a corporation, do you have a corporate resolution by the board of directors issuing you the authority to list the property? If it's an LLC or something like that, or a court order that's clear on its face that you have the authority to act on behalf of this property and all of the owners, even those who may be objecting in court but not in the marketplace. There's also the code of ethics, because again, your duty is to be truthful and honest, which is Article 2 of the Code of Ethics, to cooperate with other agents, And from that standpoint, if I'm another agent and I think that you have the right to sell this property and you only have the right to act on behalf of one of the sellers, then I'm obviously wasting my time perhaps, and that needs to be something that's conveyed. So what does the MLS say about this? Well, MLS has a very specific rule, and that is in rule number 8.2 of the MLS rules. And it is pretty clear. And what it says is, I'm going to read it to you as soon as I can dig it out here. Um, it says essentially that you must have all necessary signatures. Any listing broker filing any property as a listing with the MLS shall have a written listing agreement with all necessary signatures in their possession. Only listings that create an agency relationship between the sellers, plural, and the listing broker are eligible for submission to the MLS. By submitting a listing to the MLS, listing broker represents that they have in their possession such written agreements, could be resolutions, could be any other document that gives the authority to establish agency and the representative type of listing. The MLS shall have the right to demand at any time a copy of that documentation, any written authorization, and any documentation relevant to the rules. That also applies to Lori at the association. If something comes up in the context of a ethics or arbitration matter, Lori can request all of the documentation in your possession. And if the participant or the subscriber fails to provide documentation requested, by the association or the MLS within 1 day of the AOR having made that request. The listing can be immediately removed from the database. So there's also requirements for accuracy. There's requirements for other types of confirmation. And at the very least, you have to put in agent remarks a disclosure that you are obtaining or have not yet obtained everything that you're supposed to have. And again, just remember, one to sell or one to list, two to sell doesn't necessarily apply in the MLS. What about the licensing agency? Well, I sent an email to the Department of Real Estate, got back a response from the chief counsel, and I'm going to read it to you. As for your question, I'm not aware of anything in the real estate law that explicitly permits or prohibits one to list, two to sell practice. Depending upon how that is handled, however, I could foresee potential liability, licensee discipline for misrepresenting. In other words, for failing to provide all of the information. The best or cleanest practice would be obtaining all needed signatures on the listing agreement before listing or marketing of a property for sale. Not everyone follows the best or cleanest practice, which is why I get to stay in business. Licensees who move forward with marketing listing based on one but not all signatories on board need to proceed cautiously to avoid making misrepresentations. That's going to be the DRE's big issue. Are you either impliedly, specifically, or negligently misrepresenting something in your conduct? The potential exposure extends beyond misrepresentation and could include other disciplinary grounds if appropriate representations are being made. In other words, not accepting offers conditional unless and until accepted by all sellers, etc. I doubt that DRE will seek license discipline. So again, be honest. That's the bottom line here. Be honest, be truthful, and in that context, you probably will be okay. And then again, there's the fact that you again need to follow the code of ethics and just be truthful. So again, there is no explicit restriction And so when the hotline says, yeah, it takes one to sell, two to list, that is the conclusionary statement. But as we've seen, there's a lot more for you to consider, and not the least of which is your own practical time. Because if you're marketing a property and going to the extent that you all go to market properties and sell and take the time, energy, and money to get a property listed for sale, then to find out that later on you don't have all the written agreements, maybe somebody lied to you, you're going to be um, in difficulty. And so just be, as with almost everything else, be cautious, be honest, do what's best for your client, but don't presume without either legal advice or without a clear-cut understanding of what comes next, that you're going to be able to get everything taken care of. So that's basically it for that issue. I'm sure there'll be more to discuss down the road. Um, the other thing I want to tell you, just a couple of really quick updates. Number one, I've talked in the past about artificial intelligence and your need to be as truthful and honest and careful as you can. There's nothing wrong with AI. It's the future. It's going to get bigger and hopefully better. My son-in-law is an AI designer, and what they're planning for your future is pretty incredible. But I was told yesterday that there is now a complaint that's been filed at the Department of Real Estate against a broker because the broker has been using AI instead of conducting licensed activity through an agent or through another broker. They're using AI. They've gone too far. AI is actually handling things that a licensee should be handling, and there is now a complaint. So be very, very careful. Another issue that's, again, I'm going to be reporting on in much more detail as we move down the road here, is this whole concept of a private or exclusive listing platform. I know that there are companies out there that are pushing it, and I'm not rendering an opinion pro or con. I don't set policy. I'm just a lawyer. But I want you to understand that if you're going to be engaging in or working with or experiencing someone who is utilizing a private listing service, you need to be aware that the federal government is weighing in, that there are some legal issues. Just always remember, without exception, that the issues are going to be, did you act in your client's best interests? The issue is not, does your client know or is aware? Because I know a lot of stuff, I don't understand the reason for it. I take a lot of medicine sometimes that I do because my doctor told me to. I may do something relative to my investments because my financial planner makes it a recommendation, but that doesn't necessarily mean it's going to be in my best interest. And at the Department of Real Estate, and in the civil courts, that's going to be the criteria. Is your client fully knowledgeable and are you acting in their best interest, not your personal interest? And so as we move through what's being debated and what's being argued and what's being sued on and what's being threatened, we need to keep in mind one central fact for those of you in the trenches on a daily basis. Are you acting in the best interest of your client? If you are, and the client's fully aware and has been properly disclosed, and you've discharged your fiduciary responsibilities, and you're not misrepresenting anything, and you're not overstating anything, then we'll see what the market does with all these private listing issues. So we're going to be spending a lot of time on both AI and private listings on a go-forward basis. You need to pay attention to what Lori puts out, to what the professional standards has to say about these things, because we are monitoring these issues on a regular basis. And I believe that these two issues are going to be critical to future developments in risk management as it applies to association members. So that's it for now. A lot of big stuff. Let Lori know or let me know by email if there's another topic that you want to talk about or if any questions came up from today. And we'll see you next time. And until then, it's John Giardinelli saying thank you for attending, and I look forward to seeing all of you down the road.